This man was accused of driving despite a court order not to. However, the defense attorney argued that there was never a valid suspension on his client's license. Watch the heated exchange between the defense attorney and Judge Fleischer.
This is an ALR dismissal order.
Oh, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
But
The concern was that he was drinking. And
Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, it does show to be eligible to.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had
more
to go
time.
to the doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge. I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on the license. It's the license.
And what are the days that he's alleged to be driving?
The second, Judge, he don't check.
Does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services tells you something doesn't. Really? Is that what it's now come to?
This is all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension ever. I got the case dismissed.
Regardless, Mr. Johnson, a court order is a court
I
order.
understand.
If you ever do this again, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel.